Hello everyone and welcome to the Bird & Bird International L&E Club. In this podcast series, we will hear from our international team of employment law experts on a variety of cutting-edge topics. Each episode will provide 5 key takeaways on a key L&E theme with a US focus in 10 minutes. I'm Patty Walsh, a US-based partner within the L&E group here at Bird & Bird, and I co-head our San Francisco office. Hello everybody and welcome to our L&E Club podcast series, 5 key takeaways in 10 minutes. And today I have with me Katharina Klumpp. Katharina and I work together all the time and she's a partner in our German office. And the question for Katharina today, which is a question that's asked all the time, is around business transfers. So, Katharina, business transfers, looking at the people agenda, what do we need to know?
Many thanks, Patty. You know, it's probably a funny story why I came up with this topic. Earlier this year, I did a seminar together with a colleague on the concept of business transfers to an international audience. And there was a US lawyer in the audience, and he raised a very simple question and said, but if I want to buy assets, why would I take people? I think it's a very fair question, and this is why I came up with this topic. The concept of a business transfer is based on European law, the European Acquired Rights Directive, in short ARD, that applies in the EU as well as in the UK. The UK has transposed this European directive under a regulation called Transfer of Undertakings, Protection of Employment, in short TUPE. Hence the term ARD or TUPE, same as business transfers or transfer of business, all refer to the same concept. Patty, I believe there's another podcast on Brexit that also touches on the impact on TUPE, right?
Yeah, Katharina, that's absolutely right. Our London colleague, Rob Briggs, talks about this expressly in podcast 3.
So that's perfect. I can just shape it out here from my part. Well, a transfer of business or transfer of undertaking can occur where an organization or a part of an organization is transferred from one employer to another and maintains its identity. So the practical question is, what does this actually mean? By way of example, if you imagine a production site and there's a huge machine with 10 people working on the machine, let's imagine that the machine will be sold to another company that continues to produce the exact same product with this machine. In such a context, it is the intention of the transfer rules to ensure that the employees working at the machine will not lose their job over the sale of the machine, but will transfer along with the machine to continue working at the buyer entity. This is, of course, a very simple illustration, and the topic of transfers of business is much more complex than this example. I fully understand it. And to make it even more complex, a transfer of business can even be triggered without buying assets, such as the concept of service provision change in the UK or a transfer of personnel here in Germany. Nevertheless, I believe that this picture is a great starting point to understand what ARD provisions in essence are. And to be very simple, those are employee protection rules to secure employment as well as terms and conditions of employment in such a context. To circle back to my initial comment, even if the intention is to simply buy assets, it may be that such acquisition triggers an automatic transfer of employees. And this is our topic for today. So what are my 5 key takeaways on this topic? The first key takeaway, and this is really the most important, I believe, is about awareness that a transfer of business can happen. It still in practice happens sometimes that clients are not even aware of the concept of a transfer of business or are at least not fully aware of its practical implications. As I said earlier, the topic is quite complex, and this starts with the definition of the assessment in which circumstances a transfer of business may be triggered. To break it short, it will not be possible to solve this miracle as part of this podcast, Whether a certain situation will trigger a transfer of business or not will often only be answered by a court after lengthy court procedures long after the actual occurrence. Therefore, also please keep in mind the ARD rules are based on a European directive, meaning there is a European directive that sets a framework, but then there is local law in each EU member state, as well as in the UK, to transpose the directive into local laws, meaning that there is a great variety and tiny little differences between countries. As a rule of thumb, and I'm trying to keep this really, really simple, a transfer of business usually requires that an organization or part of an organization is transferred from one employer to another and maintains its identity. Practically, this often happens in the context either of, as I said before, buying assets, tangible or intangible. And this can be the full acquisition of a legal entity by way of an asset deal. But it can also be a situation where a company only intends to acquire certain individual assets. Very common example is acquisition of patents, where often companies are not aware that this already can be sufficient to trigger an automatic transfer of business. Then the other typical example is taking over personnel from another company or providing services that previously have been provided by someone else. I think these are the three typical situations where your alarm bells should start to ring, being aware that this is a standard situation where a transfer of business could happen. The second key takeaway is about the consequences of such a transfer of business. First of all, you may end up in a situation where you as a company may inherit employees that you do not necessarily need, as you likely have already made your own plans how to staff your operation. Please remember what I said initially. ARD regulations are employee protection rules, and most prominent, it is not possible to terminate employees because of such transfer. This means it is not possible to circumvent the concept of a transfer of business by simply terminating the employment relationships. Again, the exact regulations differ quite relevantly from country to country, and in some countries, it is not possible to terminate employees at all in the context of a business transfer, whereas in other countries, it may be possible to terminate. However, this will then require a justification that is unrelated to the transfer of business. It is not only the protection of the existence of employment relationships. So in addition to the protection against dismissal, you should also be aware that under a transfer of business, the employment relationships will transfer in their as-is status. This means that employees will bring their current terms and conditions of employment. And obviously, this has a financial impact, but it also has a cultural impact, especially if you plan to integrate two organizations following such a transfer. By way of example, you may have a very lean organization so far, and under a transfer of business may inherit a fully mature works council organization, trade union involvement, etc., etc. There may also be terms and conditions that limit the future right to reorganize or to terminate such employment relationships. In Germany, depending on the industry and type of the company, it is not unusual to have either works council agreements or collective bargaining agreements with trade union that relevantly regulate the daily work life. Another very common example is working time arrangements that exist within an organization. So on this takeaway, to break it short, it is absolutely key to do a due diligence process before such a transfer so that you're actually aware of what you will inherit under the business transfer. A third key takeaway is again awareness, but this time in relation to potential liability. The idea of a transfer of business is not only to avoid termination of employment, but it is actually to secure the continuation of existing employment relationships. We just discussed that employment relationships will transfer in their as-is status. This does not only mean that the new employer may not be in a position to reduce certain benefits or even salaries, but this also means that the new company will be treated as if the employees had worked with the new employer from the start of their employment relationship. Consequently, it is not only a question of future obligations towards employees, but a transfer of business also entails liability for anything that has already been granted in the past by the former employer. In countries that do not have the concept of a transfer of business, a company would simply hire employees or terminate employment relationships with one employer and then start from scratch with the new employer, and consequently also agree on new terms and conditions of employment with certainly no liability for any past services. Same as before, as the transfer rules are statutory protection rules, it is not possible to circumvent the concept based on mutual agreement. By way of example, and in relation to continued years of service for the calculation of benefits, for example, severance entitlements in Germany are typically calculated based on the previous or the entire length of service. This is a standard topic. But there may be even a bigger financial impact in relation to company pension schemes. In most countries, these will be defined contribution schemes, but even such schemes may come with additional liability. And for example, in Germany, again, sorry that I always use Germany as an example, it at least was or used to be common in the past to also offer defined benefit schemes. Under a transfer of business and with no additional arrangement between the two companies, the new employer will then also inherit all liability for future pension payments based on the past service that the employees have completed with the former employer. And you can imagine that this will typically have very relevant financial impact. Again, it is a very complex topic, and there are certainly many variations in the different jurisdictions. But the key takeaway should again be that you need a certain level of awareness also in relation to the financial implications of such a business transfer. My fourth key takeaway is then a more practical one. So it's not about awareness, but it's a very pragmatic one. Transfers of business also trigger certain consultation requirements, and these may have an impact on the timing of your overall project. Consultation requirements again differ from country to country, but from a very high level perspective, it is most important to understand that there are such consultation requirements in all countries and that these will have an impact on the overall timing. Again, I believe my main point in this regard is to increase awareness, also with a view to the potential overall project planning and timing. My last takeaway is then really a practical one, and this is about the practical handling of a business transfer. After having discussed about all the different alarm bells that should ring in your head, I really would like to comment on a very practical point. Earlier, we discussed that the assessment whether transfer of business is triggered or not is often rather difficult. By way of example, if you are the current employer, you will not know exactly what the future organization will look like, so that it is really difficult to assess if any organization will likely retain its identity or not. Quite similar, if you're on the receiving end, you will have to rely on the information that the current employer provides to you and the description on the organizational unit that likely will transfer. Please also keep in mind that both parties may, for various reasons, wish for the transfer regulations to apply or not to apply, and hence may, to the extent possible, shape the factual situation in a way that facilitates one scenario or the other. In this regard, it is also important to keep in mind that the current employer, of course, is able to shape an organization in a way to support the intended outcome. For example, pick individuals that the company wants to retain and offer them employment elsewhere within the organization so that they are not impacted under such a transfer. it is rather unlikely to assume that any company will easily give away anything or will give away any employees that they wish to retain, but likely they will rather shape the organization, make sure that such individuals will be moved to a unit or to an organization that is not impacted on any automatic transfer. So what is then the pragmatic approach how to deal with that? Typically, parties will try to establish a mutual understanding on whether a situation will trigger an automatic transfer or not. It is not possible to agree on whether a transfer occurs or not. This is a matter of statutory law and not a matter of agreement between parties. Nevertheless, the practical handling typically is to reach a mutual understanding between the parties whether it is intended to transfer employees automatically or not to transfer, and then ideally work together to shape the process in a way to support such concept and ultimately reach a commercial agreement between the parties on the allocation of liability and costs in consequence of an intended transfer of business or to cover for the consequences of a transfer that was not intended. I believe, to conclude, the concept of a transfer of business is not such a big mystery, but in order to pragmatically manage the concept, it is absolutely key to be aware of the concept as well as to be aware of its implications. Now, back to you, Patty.
Katharina, I think you have totally demystified one of the most complex and anxiety-inducing topics. Thank you so much.
You're welcome. Thank you.
Thank you for listening to today's podcast. We hope you join us again and look out for more content coming soon.